you. Okay. Okay, so can everyone hear me? Thank you so much. So I haven't written a speech in entirety because I talk about this so much. And I'm like, to read it would make it kind of boring. I can speak about it. There's just one part that I will read, which is explaining the constitutional challenge, because no matter how many times it's explained to me, I can't remember it. So first of all, so thank you everyone for coming and listening. And I'll start off by just giving some background. So in should I put it up a bit? Okay. In 2018 and 2019, my mum, who's actually here today, we came up with the idea for a social networking app for women. We didn't know about this stuff that was happening. It was my mum that had the idea. We were going to just do a roommate app for women, and then when we found out sort of it was expensive to create an app, and we've kind of got a good idea here, let's sort of scale it. What other things could women want to use an app like this for? So I sort of created this startup where it would be an app for women to go to find roommates, freelance work, travel companions, buddies, emotional support, lesbian dating, so many things. I mean, pet sitting, pen pals. Like we tried anything. I think we had like 84 categories or something, and we knew that there would be men that would want to try and get onto it. I knew enough about just sort of living in the world that when something is for women, that there are certain types of men who are more interested in it then. So it was actually my dad who discovered this software that we could have that was badly named gender recognition software, but using gender as the polite synonym for sex, which especially for American companies, that's very, very common. And so basically it would just be software that you take a selfie and it would scan it, and AI would say the likelihood of male or female. And it worked. We did testing on it. It was cool, amazing. While trans activists have a lot of criticisms of and lies about it, none of them are true. It actually just did work, and it was really, really great. We had it set to 94% accuracy because we'd found through testing that basically it would not knock back women, and we didn't want women to ever be knocked back from it. And occasionally it might let a man on, but we'd just remove him. Rightly or wrongly, that's the decision we made. So we spent all of 2019 developing it, building it, like getting that built. I mean, I didn't build it, like app professionals did that. And then in February of 2020, when we were on the App Store and Google Play doing testing, not many women in the world knew about it. We woke up one morning to thousands upon thousands of men on the app. All of the security measures weren't in place. They all got on. They were making profiles saying rape TERFs, kill TERFs. I'd never heard the word TERF before. They had inundated the App Store and Google Play with one-star reviews and like 1 stars and then negative reviews calling us transphobic. I'd never been called transphobic before. And we were panicking. I had no idea what was going on. But I was introduced to this with basically the worst side of what trans activists do. So I decided to do a bit of research, and it didn't take long. I'm talking minutes to realize that the women who had been speaking up about this for a long time, who I found pretty quickly, I just typed in the word TERF to Twitter, and like Helen Joyce and Jane Clare Jones and all of these amazing women came up, and I was just reading everything and seeing that lesbians were being told to accept men as lesbians. I saw that Muslim women who are fighting to stop female genital mutilation were called transphobic for using words like female and genital mutilation, and I couldn't believe it. And so I sort of studied and learned as much as possible until it became really clear that I would have to say something, just in part because of what was happening to women, but then what was happening to us. We had to start up, and we were cancelled right out of the gate, basically. And I remember saying to Mum, I was like, this will be over really quickly. Like, it'll be a few months, because in my mind, it was so insane what was being said. They were saying men are actually women. I was like, no one actually believes this. Turns out they do. So basically, we made a decision as a company to just kind of tread water. As I said, I thought it would be over really quickly, so we would just basically run it as cheaply as possible and just be there. It would pass, and then we'd be able to move on and just create an online space for women. However, in that time, so kind of time was just going past, and in 2021, a man got on the app. I don't remember removing him because it wasn't an event. So we would have huge attacks where there'd be thousands upon thousands of men, even in an hour, trying to get on, and they wouldn't. The thing would block them. Every now and then, as I said, one would get through and we'd remove them. I don't remember all of these men. There was probably a few hundred that I removed over the course of the 2 years the app was up. So I removed this one particular man at some point, and then in October 2021, I can't remember if it was a missed call first or a text, whichever way it went, but basically I had a missed call and a text from someone called Roxy Tickle saying, I'm trying to get onto the app. And so I typed his phone number into Giggle's surfer and I saw a picture of a man. And I called my dad and I said, a guy who's trying to get on, or has been blocked from Giggle, he'd already been blocked, has called and texted my phone. This is really weird. And Dad said, block his phone number from your phone and don't tell your mum, because mum sees the threats we all get. And so I did. I just blocked his phone number. No one else has ever called or texted my phone, only this person. So I just kind of, when something freaks you up, you sort of try to forget about it, like, oh, it didn't happen, because I found it really weird. 2 months after that, I got an Australian Human Rights Commission complaint for alleged gender identity discrimination. And so I called Kath Deves first and said, what do I do? She said, get a solicitor. This will be serious. And basically, so with Anna Kerr from the Feminist Legal Clinic, we worked to, in a sense, try to get it dismissed from the Australian Human Rights Commission of stating that women also have rights, how the Sex Discrimination Act works. Basically, the Sex Discrimination Act, it was created, I'll go into this more, but it was created essentially specifically to protect female-only spaces. It was the exemption in law to allow female spaces, female sport. Any protections specifically for females were protected under the Sex Discrimination Act. There was no other purpose for it. And so that wasn't the intention of the Act. So that was essentially our argument in the AHRC. The Australian Human Rights Commission did not care at all. They basically said to us that to settle it in the AHRC, I'd have to go to conciliation, which is sort of sit in a room with Roxanne Tickle. I would have to agree to let him on the app, let all men who claim to be women on the app, attend sex and gender education, which could only be re-education, because I could teach that class better than any of them that are currently doing it, and moderate all content on the app so not to offend any men who claim to be women. I said no to this. For that reason, I was never going to agree to any of it, so it was a waste of everyone's time. But also by this point, I was 15 weeks pregnant when we got the complaint, and so at this point I was just getting more and more pregnant, so I wasn't putting myself through that. So I said no to conciliation, knowing that it ran the risk of it escalating to federal court. But I didn't have a choice. It was either just agree to him or take the risk. So he did file in federal court. This is sort of a bit of a boring story, but just to gloss over it a bit. He filed, and then about 6 weeks later, he actually withdrew. And then 6 months later, he filed again on the same initial complaint. When you, with the AHRC, it's dismissed from there and you can go and file in federal court, you have 60 days to do it. He did it on the 60th day. He withdrew 6 weeks later, then 6 months later, refiled again on that initial claim. So he had to get permission from the federal court for the case to go ahead. So that's why, if anyone's been following this, it feels like it's been going for a lot longer than a case would. If he hadn't done that, we'd be past the High Court by now. So it's dragged on for much longer than it ever needed to be. He claimed that he withdrew because of money, because he didn't have any. Now he does. He got a grant from the Grata Fund and a pro bono legal team. So basically when a case like this goes to the federal court, so the charge is gender identity discrimination, they have to prove that gender identity discrimination happened, or you would think actually this is how it goes, that they would have to prove gender identity discrimination happened and we have to prove that it didn't. Their case is basically he's a woman. Ta-da, that's effectively the case. The Australian Human Rights Commission, however, intervened in August last year as amicus curiae, which is not completely abnormal for the Australian Human Rights Commission to do. They have a statutory right to do it into any federal court case. Amicus curiae means that friend of the court, so they're there to interpret the law. When they applied to be amicus curiae, so you have to get permission, but they were always going to get it, so that was fine. But they admitted that there is a conflict of sex and gender in the Sex Discrimination Act. And when I read that, I was like, that's the TERF position. That's what we've all been saying. They then proceed to try and solve it with gender identity. But that's a really important document. It's actually on the Federal Court website. If you type in Tickle v Giggle, you can read it. You can read their intervention submission, and then you can read their actual submission into the case. And I recommend everyone doing it, because that intervention document, where they admit that there is a conflict in the law, will be important later on. Yeah. So the Australian Human Rights Commission, they have an interest in defending gender identity in the Sex Discrimination Act because they are the organisation that got it there. They lobbied for the 2013 amendments under the Julia Gillard government to have gender identity put in. So beforehand, from 1984 until 2013, woman had a definition. It was adult female. It was actually quite an odd definition, actually. It was slightly wrong. It was a woman, a female woman of any age. I was like, no. So it was a tiny little problem with it there, but we could work with that inaccuracy. But anyway, what happened in 2013 is they took out the definition of woman and the definition of man, to be fair, and they put in gender identity, and they gave it a definition which is something to the effect of like gender identity is a person's mannerisms. And behaviour is another one. It can be linked to sex, it cannot be, you don't have to get surgery, or you can if you want. It's just nothing, it's a circular nothing definition. So anyway, in 2013 they got it in there. What that means is that from 2013 to now, the Sex Discrimination Act has been muddled. Now there is a case to be made that sex still, all of our protections are still there, because they didn't take out any of the stuff. They just added in this one thing of gender identity. It's very muddled. Like Claire Chandler, who's the senator in Tasmania, when we're still in AHRC days, she called me and she said, like, this has never been challenged in legislation, and it needs to, and it won't hold up to scrutiny, so just hang in there, it'll be fine. And I remember that constantly. So basically, we are the first case that's come along to challenge it. It does not mean that it's been working fine since 2013. Most women-only gyms, women-only organisations, most of them have just fallen to this ideology. There's a few who didn't want to. Most have like happily fallen because they've been infiltrated from some other way, but they most have just sort of fallen to it. We just sort of felt like we had no choice. I mean, if I let men who claim to be women into Giggle, it's like, congratulations to me, I've invented Twitter. Like, there's literally no point to it. So in federal courts, this is the part where I have to read it because I don't completely remember it. So in federal court, it's very much a he said, she said process. It's establishing if gender discrimination happened. And so part of our defense for that is a constitutional challenge. This is because it shouldn't even be that anyone is being taken to federal court for gender identity. And so not only did I not do it, it shouldn't be there in the first place, because as the original intention of the Sex Discrimination Act, I actually was following the law. So a constitutional challenge challenges the validity of a law. So in this context, it's whether gender identity should even be in the Sex Discrimination Act. So spoiler alert, it shouldn't be. So Commonwealth laws derive their power from Section 51 of the Constitution. Section 51 of the Constitution of Australia enumerates legislative powers granted to the Parliament of Australia by the Australian states at Federation. Each subsection or head of power provides a topic under which the Parliament is empowered to make laws. That's why I never remember this stuff. There are other sections in the Constitution that enable the Parliament to enact laws, although the scope of those other sections are generally limited in comparison with Section 51. So then you have the external affairs power. This supports laws with respect to matters physically external to Australia and laws affecting Australia's relations with other nations. So how laws are valid, federal Parliament can only make laws that are based on the heads of power and the external affairs power that allows the Australian government to sign international treaties and conventions on behalf of the Australian people. This process, the treaties and conventions, dictate what the law will be, as they have to exist in relation to international law. So in the Tickle v. Giggle case is gender identity versus sex, to put it as simply as possible. And it's the first time there has been a case, not only in Australia, but worldwide, that is directly dealing with the conflict of gender identity versus sex and its relationship to CEDAW. CEDAW is really, really important. So CEDAW is the Convention of the Elimination of All Forms of Discrimination Against Women. It's basically an international Bill of Rights for women, and it has been ratified by 189 countries. That means that it has been approved or enacted in a legally binding act that would not otherwise be binding in the absence of the approval. So the UN General Assembly adopted CEDAW in 1979 and Australia ratified it in 1983. So after Australia ratified CEDAW, we had to give effect to it. So we had to do something with it, and that's when we did the Sex Discrimination Act. What makes Australia and New Zealand very, very unique is our sex discrimination acts are effectively CEDAW, word for word. So in 2013, the amendments to the Sex Discrimination Act under the Gillard government brought in gender identity. So they had no legal basis for inserting gender identity because there is no reference to gender identity in CEDAW. And the Sex Discrimination Act is based on CEDAW. CEDAW is for females. There's absolutely no mention of gender identity in the context of having a gender identity beyond being female in CEDAW. The Sex Discrimination Act was written purely for females. That was the intention. So now for the gender identity side, the defence of gender identity being in the Sex Discrimination Act is the Yogyakarta Principles, which do mention gender identity. The Yogyakarta Principles are a document about human rights in the areas of sexual orientation and gender identity that was published as an outcome of an international meeting on human rights groups. However, the Yogyakarta Principles have no legal validity in any jurisdiction in the world and have been rejected by the UN on multiple occasions. For them to be accepted by CEDAW, for example, all signatories of CEDAW would have to approve them. This has not happened. The Yogyakarta Principles are essentially minutes to a meeting, and activists have pushed them as if they are a ratified treaty. They are not. There are a few ratified treaties that are connected to CEDAW because they do add things sometimes, and they sort of just try and tweak the sort of the edges of things. So there's one document that has been ratified in relation to CEDAW, and it says sexual orientation and other status. And the entire argument for gender identity being in law is that other status means gender identity. Yeah. So in April of this year, we had the hearing for Tickle v. Giggle after an exhausting long time. So I can't talk too much about it. I'm just not allowed to. I can talk about stuff that's in the public domain, but I'm not allowed to speculate or anything. It was a 3-day hearing. There is stuff online. There's a very funny story about a sweaty balls scandal. So basically now we're waiting for the verdict. So the verdict, it's a totally normal time period for between 2 to 6 months. They have to go through the judge has to go through everything and write up the thing. So while I see a lot of things all the time going, it's taking so long to decide what a woman is. No, because what he's doing is trying to, yes, in one sense, but what he's trying to do is apply the law to all of the evidence in the case. And surprisingly, there's no evidence that he's a woman, so that'll be interesting. So what will happen is, I've been told since the EHRC days that this case was going to the High Court no matter what, because whether it's me who's not going to accept it, or either the Tickle side, but very much the Australian Human Rights Commission side, aren't going to stop fighting until they have no other choice. Like the Australian Human Rights Commission right now will not change their stance unless they're made to. It's as simple as that. So once a verdict comes in, you have 28 days. First of all, we actually have to apply. There is a small appeals process in the federal court. You go to the federal court bench, where there's 3 judges, and you just have to convince 2 of them. Again, either side's going to go to High Court with it, so it will just be another sort of just stop on the journey. Then it will be the High Court. Once we go to High Court, it's actually not Giggle v. Tickle anymore. It's either the government against Giggle or Giggle against the government, basically. Because it's a straight up constitutional challenge at that point. The he said, she said of it doesn't matter. Now, just before the hearing, Reem Al-Salim, who's the Special Rapporteur for the UN for the discrimination and violence against women, I can't remember her exact title, but I think hopefully everyone knows who she is. She actually wrote to the Australian Human Rights Commission informing them that gender identity is not included in CEDAW. We are correct, CEDAW is for females. So we are right on that side. If we had legislators in Australia who were listening, who were across the board on this, they could fix this in a week. They could take all of the information and go and say these amendments are unconstitutional, they need to be removed. They could go and put gender identity somewhere else in some other law that doesn't impinge upon anybody else's rights, but they don't do that. So that's one of the things that's most important between now and the High Court is the court of public opinion. So we know that when normal people hear about this issue, they are on our side. I can't tell you how many people have contacted me after Tickle v Giggle, but not one of them went, I think he's a woman. Not one. Like thousands of people. So we have to just keep it going. So in the High Court, so say we go to the High Court, we win a constitutional challenge, and they go, yes, these amendments are unconstitutional. So the legal precedent will have been set instantly. It will mean that sex has weight in the Sex Discrimination Act. It will mean female spaces are legal. It will mean that all state gender laws are, I've just lost the word, but they're like in conflict with the sex discrimination, with federal legislation, basically. What will then have to happen, it won't be like we wake up the next day and it's like, oh, it's all done. Thankfully, it is the horrible reality that it's still going to take a long time to undo all of the damage that's been done. Because while the legal precedent will be there, we'll just have to then campaign to legislators to make sure everything is changed actually in law. They are much more willing to do that if there is a High Court ruling that's telling them to do it. At the moment, they have no reason to do it because there just isn't the political appetite for it. We have the Fourth Estate against us, essentially, so not enough people are aware of it. More and more are waking up, so I'm not worried about that. I think over the next year, 18 months, it's really going to change. But it would mean we'd be able to go to states and they would have to take away self-ID. It's done, it's gone. So long as sex is defined as sex and women and men have their normal, accurate definitions in the Federal Sex Discrimination Act, everything else falls away. So if we were to lose in the High Court, we have a much higher chance of winning in the High Court, I will say that. But if we were to lose in the High Court, again, it's a situation of getting it to that point and having the exposure of the issue and the details, and then being able to use that to pressure legislators. It might sound like a long shot, but it actually isn't, even if you have a loss, because last year there was a really bad High Court ruling, and it was the one with the refugees with criminal records, like the pedophiles and rapists, and then the High Court, because they didn't have anywhere to send them to, the High Court said they had to release them into Australia, and they all reoffended within 2 weeks. None of us knew that was happening. That was even a thing, that you could just be an illegal immigrant with a pedophile criminal record and be released into society. Turns out you could, because there wasn't any legislation on it. What happened, because of the High Court ruling and then the public became aware and the complaints, legislators got moving and they changed that law really, really quickly. So it's the same thing. At the moment, because there's a lot of people that just don't understand what's happening. Because if you read The Guardian and the ABC, you have no idea that there is a problem. They also don't understand how it can affect them. So now I say this all the time, obviously I'm coming at this issue from female spaces and women's rights, but the Sex Discrimination Act and having these definitions in law actually trickles down to everybody. So not only was it obviously for children, for girls at school, bathrooms and whatnot, but also in employment. So having some kind of legislation to protect you, whether it is the environment, so saying going for bathrooms and whatnot in employment, but also for pronouns. free speech. At the moment, there is absolutely no legislation in Australia protecting anyone from that. So while we do definitely need like the Mayor Force-Data specific employment case, every little bit bleeds into the next one. And so once we have the definition of woman back in law, everybody's rights are lifted. So basically, over the next few months, I will keep everyone updated. As soon as I know that there's going to be a verdict, I'll let everybody know. It will basically be, we'll get told that a verdict is coming in a week or so. Like every time Kath Deeves calls at the moment, she has to answer and go, no verdict yet, I'm talking about something completely different. My heart skips a beat. But it should be in the next few months. And then so we'll know, yeah, this is the date that the verdict will be announced, and then we will go there and find out what's happening next. I'll say this, I would prefer to be the one taking it to the High Court. My reason is, I feel I've had no choice in all of this stuff in the last few years, and it would be the first time that I get to have a choice in what happens. And that I get to take a stance rather than just being the respondent of it all. I get to say, no, I want to go further with it because it's important to me and by extension to everybody else. So thank you so much to everybody for your support. The crowdfunder is still up. If we have to go to federal court, it's going to be at least another 500,000 to 750. From my experience with lawyers, I think it will be closer to 750. They don't give you change. But I mean, I'm not officially crowdfunding at the moment until we have a verdict. So, but that it's still up. All information is on there. It's all detailed. I didn't write it. It was actually written by the lawyers. If you want more detail about CDAW and the Sex Discrimination Act and what they did and why it's important to everybody, all the information is there at gigglecrowdfund.com. But everyone, thank you so much for your support. It means the world to me.